What I'm about to tell you is a very personal story. One I hope you will find interesting. I also hope you'll ask questions because, as Benny said, I'm an old appellate lawyer and I ask questions. There's never a bad question. I only give bad answers. I became enamored with the law as far back as 4th grade when I was introduced to Talmud. The intricacy of the debate, the many angles which the sages used to explore practical halakhic questions, I found very intriguing. I'm pretty certain that my decision to become a lawyer was probably made unconsciously around that time in those formative years. But being exposed to Talmud also served me well as I progressed to a career, a 32-year career, as an appellate prosecutor, and those included the entire period encompassing Connecticut's modern death penalty litigation. Over 22 years, I was involved in every capital case prosecuted in Connecticut. I was also involved in the legislative debate about changes to the capital sentencing scheme. I would meet with legislators, sometimes caucuses. A caucus is a small group of legislators, usually from the same party. And I even sat beside one of the legislators during the floor debate, and when questions were being asked, I'd whisper in his ear and he would answer them. I became what was considered one of the state's experts in capital punishment. But it didn't start out that way. I'm going to discuss today how I got to that position, and particularly how I reconciled my religious and personal beliefs with the task of enforcing Connecticut's death penalty. It was something that I had to do because once I swore an oath to the state of Connecticut to support the statutes and Constitution, I felt I had that obligation regardless of whether or not I agreed with the position of the death penalty, having it or not. The story will take us back to 1992 and Connecticut's first capital case, because that's when I came face to face with the issues. First, however, before I go through the history, I have to have a brief digression on 2 points in my life when I realized the value of my limited Jewish day school education, because I think it will illuminate what I have to say. In my first year of law school, my property professor started the term discussing the law of bailments. Anybody here familiar with bailments? It's a property issue. During the first few weeks of class, I somehow knew all the answers. My hand would just shoot up, real fast. Even though when I read this stuff, I didn't understand it at all. But you see, I had learned this when I studied the Gemara El Mitziot. I learned the difference between a shomer chinam, someone who watches something for free, a shomer sachar, someone who's hired to watch something, and a shoel, someone who borrows an object, what their relative responsibilities were. And I didn't need a professor, and I didn't need a property book to teach me that. My second experience was similar. When I was the new kid in the appellate bureau, now we're going back 32 years, real history, I was surrounded by some brilliant people, and I was the new kid on the block. Each day at lunch, we would sit around a table not as big as this, and we'd talk about our cases. And it was a proving ground for new attorneys. They wanted to find out, is this guy smart? Is he stupid? Is he adult? Well, it just so happened that simultaneously I was studying Gemara on Monday nights. And then it happened on Tuesdays. Week after week after week, I would start solving my colleagues' really sticky problems. And they had the same questions as the students in class. How can you do this? And I said, well, I just had Talmud class the night before. And they said, are you studying search and seizure and the right to confront witnesses and, coerce confessions in Talmud class? I said, no, it's not that. It's the reasoning process. It's taking the question and turning it around. And after class, we had turned around a particular halachic issue in the Gemara class. And after class, I started taking your issue and turning it. And I got to a certain point where I said, from this direction, if you approached it from this direction, I think you might have a solution. And those two experiences taught me the utility of my Torah education, and I think played a large role in what I will be describing to you as we go on. In 1962, I worked in the Appellate Bureau of the Chief State's Attorney's Office. We got the first capital case, State versus Michael Ross. Ross was a serial rapist and killer. He would drive around a sparsely populated area of southeastern Connecticut where he lived and worked. And when he saw teenage girls just walking on the side of the street or hitchhiking, he'd pick them up and offer them a ride. It was their final ride. Ross would kidnap them, take them to a secluded area, rape them, and murder them. His weapon of choice, his enormous hands. He strangled them to death. His description of what it was like to kill somebody by strangulation is gruesome, and I think it's also one of the reasons he got sentenced to death. The only clues to this series of murders was the description of a white Toyota that might have been near the spot where one of the women disappeared. There was also a kind of loose description of a thin man wearing a white shirt and dark pants who was observed briefly in the area of the disappearance. So one police investigator decided to undertake some really hard-scrabble, hard-nosed police work. He obtained from motor vehicles the list of all registered vehicles within a certain radius. He started with a tight radius, then a bigger radius, and a bigger radius, and he got all these registrations for a white Toyota. And then he decided to go knock on the door of each owner. Now remember, he had no idea how many doors he would have to knock on. In fact, he didn't even know whether the white Toyota really was related to the crime. But he decided, since everything else failed, and girls were being killed rather regularly, that he had to do this. Fortunately for possible future victims, the third door that the officer knocked on was Ross's. He greeted the officer wearing a white shirt and dark pants. He had a whole closet of white shirts and dark pants. The police officer agreed to come down to the police station, and there he confessed to 6 murders. 6 in Connecticut. He murdered elsewhere. Ross was arrested. He was tried, convicted of 4 of the murders, and sentenced to death, 6 death sentences. I can briefly explain that. Some of the victims, there were 2 capital crimes. So a sentence was considered for each crime. So if it was a rape murder, there's a death sentence for that. If it was a kidnap murder, there's a death sentence for that. The other 2 murders he pled guilty to in exchange for life sentences. When the case first came to our office in the Appellate Bureau, Connecticut was well behind other states that had pursued the death penalty aggressively since 1976. 1976 was kind of a hallmark date because that's when the United States Supreme Court decided 3 cases that basically allowed states to resume execution after a brief respite. Indeed, by 1992, Texas, Georgia, and other states had already been executing people. So we were well behind the curve. Most of the law here was very complex, and it centered around the cruel and unusual punishment clause of the 8th Amendment of the United States Constitution. As you know, the Bill of Rights, the first 10 amendments, the 8th Amendment protects against cruel and unusual punishment. To simplify what the United States Supreme Court did, in order for a death penalty to be imposed constitutionally, they demanded 2 somewhat contradictory things in the law. First, it had to narrow the class of those against whom the state could seek the death penalty by providing very specific reasons justifying the punishment. For instance, you torture somebody to death, which with many of our defendants, that was a pretty common event. The theory behind this particular narrowing was there was a concern that people were getting sentenced to death because of their race. And they thought that the more objective you made it, the less we would be concerned about race. The second contradictory aspect of it was very broad mitigating factors. They applied either to the defendant or his case. They would be evaluated by the body imposing the sentence, either a 3-judge panel or a jury, and decide whether someone who was otherwise death eligible, who met all the other requirements, would be spared and sentenced to life or sentenced to death for their crimes. These are known as the twin pillars of the 8th Amendment death penalty law and are referred to in shorthand as aggravating factors, what makes the murder worse, and mitigating factors, reasons to spare the defendant. And the reason I went into those will become apparent as we use them. All of this discussion, although a part of that moral debate was certainly settled by the legislature. When you have the legislative debates, that legislature makes moral decisions of a certain kind when they decide to pass a law and decide to punish something. but it was necessarily part of the constitutional debate for this very good reason, and I think it's a reason you're all familiar with. Knesset passes a law and says it's legal to punish someone this way. It goes to the Israeli Supreme Court. What can happen there? Cancel it, invalidate it, find it in violation of the principles of the state. The U.S. Supreme Court can do the same thing. They can find that the legislature says the death penalty is okay. The court says it's unconstitutional. And importantly, even though these moral issues have been kicked around for years in federal court, they really had a life of their own in Connecticut, because the United States is a dual sovereignty system. It's a republican system of government. There's the United States Constitution. What the United States Supreme Court says is cruel and unusual punishment is the floor. You can't go below that floor. However, the state of Connecticut, under its own constitution, can give more protection to defendants. So even though a lot of these moral debates played out in U.S. Supreme Court dialogue, they were going to play out again because Connecticut could decide their own fate constitutionally when we're dealing with the death penalty. So the question was joined. What moral right did Connecticut have to take the life of a citizen, no matter how dastardly the crime committed? This is when I joined the battle, and it was a battle. I have to tell you that I got involved because I volunteered to be part of a team that was working on this case. There were thousands of pages of transcript, thousands of records in the case. The issues themselves were complicated, and many of them were brand new. I thought I'd be assigned one of the simple issues, like Ross's confession. Should it have come into court in front of the jury or not? As fate would have it, however, a series of events catapulted me from being an assistant on the team to becoming its general. I was suddenly the lead attorney in Connecticut's first death penalty case in 40 years. And I was still relatively new in the Appellate Bureau. And it was here that my connection to the values of Jewish law and the needs of my professional career started to collide. I realized that if I succeeded in my task, dealing with Michael Ross's case, and the death sentences were upheld, it would result in the calculated death of a human being. I needed to get in touch with some halakhic sources to help inform how I felt about that. Two fortunate coincidences helped me with this dilemma. First, believe it or not, Connecticut's death penalty, dating back to 1650, is derived directly from the Torah. The original statute imposing the death penalty as a penalty for murder cited Bamidbar, Lamed Hay, verse Lamed. Now, of course, it didn't say Bamidbar, it said numbers and the like. It also cited Devarim, Yud Tet, Pasuk Tet Vav. Those were the sources. Connecticut was settled by religious Christians. When they looked for a place to find morality in their law, they looked to the Bible. And Connecticut even has a two-witness rule. Everybody know the two-witness rule? You can't be convicted of a crime except on the testimony of 2 or 3 witnesses. Connecticut codified that way back in the 1600s. That law was still on the books when Michael Ross was prosecuted in 1990. Why was the biblical history important? Why did I feel it was important? Because when you're doing constitutional law, you have to be able to discuss what was in the minds of the framers, the people who started Connecticut, who passed these death penalty laws, the people who enacted the Connecticut Constitution, which wasn't enacted until 1818. What were their bearings? What was important to them? What were their values? Because when a court is interpreting its own constitution, it wants to know that. I don't know if you've heard Justice, the late Justice Scalia was a strict constructionalist. Remember that? Have you heard that? He was a literalist. What did the Fourth Amendment mean in the 1700s? It means the same thing now. And some judges and justices look at it that way. So it was important for me to know that, but it was helpful because of the personal search that I was on. My second stroke of good luck was meeting a brilliant Chabad rabbi named Shlomo Yaffe. Shlomo loved any scholarly endeavor, especially one relevant to cutting-edge legal developments. He took an interest in my dilemma and agreed to make a 1-hour round trip to my office once a week, and we studied the Jewish law of capital punishment during lunch. Just allow me another digression here, because I think it's fascinating the way my particular office worked and the people who I worked with. My boss at the time said, "Hey, who's this rabbi coming in every week? I see this guy with a beard and a black hat, and he comes in, he's here for an hour, and he leaves. What's he doing here?" And I explained to my boss that he's studying with me the Jewish law, the death penalty, as part of my foundation for this work that I have to do. My boss said to me, "Does it help?" I said, "Not only does it help, I find it invaluable to finding my own sense of direction." He said, "Well, then it's not your lunch hour. It's part of your work. He can come more than once a week, and he can stay a little longer if you want him to." That really impressed me. Somehow, unwittingly, Torah study became actually part of my job. But just interestingly, for the last 20 years, we have a weekly Talmud class every Thursday in my office. It's attended by Jewish and non-Jewish lawyers alike, appellate lawyers like me. And one of the reasons the non-Jewish lawyers attend was because of that first story I told. They wanted to learn the thinking process. They wanted to become, schooled in that type of process. So as long as everybody can come, it's perfectly constitutional. Our task was enormous. As I think I said, our opponents filed a 300-page brief. You know the old story that only lawyers can call a 300-page document a brief? Well, they wanted to file a 430-page document, and the Chief Justice, who was a marvelously brilliant mind from a Yale professor, former Yale professor, she sent it back, and she said 300 was the end, 300 is it, no more. But they raised like 42 issues, 42 different issues. Some of them had to do with the death penalty, some of them had to do with just, as I said, the mundane issues that we always get in trial work. So I had to learn the federal law on the death penalty. I had to learn Connecticut's history to answer some of the comparisons made. I also had to learn the capital laws of the other states. I had to learn, for instance, that Massachusetts had the death penalty. Massachusetts Supreme Court found it violated the state constitution. The legislators were furious with them. They passed a new death penalty law. The Massachusetts Supreme Court reversed that death penalty statute, and the legislature never did anything in response. So those are the things I had to know about 35 states. The first issue that I dealt with in the case, and since I did the capital issues, the first issue I dealt with was the two-witness rule. The defendant argued that the state didn't present two witnesses to prove his guilt. And technically, he was correct. In a literal sense, he was absolutely correct. I learned from Shlomo, and some of you probably already know this, that halakhically the two-witness rule was a very high obstacle for prosecution. Each witness had to be independent of the other. Each witness had to view the entire crime. As you know, a crime has elements. Murder, you cause someone's death intentionally. That's the definition in Connecticut. You intend to kill, you act, and you cause the death. So they would have to actually deal with it. Now, intent in Talmudic times was dealt with differently than we deal with it today. Nevertheless, those were the elements. Each witness had to witness all of those. And you probably know that rapes and murders aren't committed in public. Usually, some people are brazen and they do it, but these were very private crimes. So he was kind of correct that technically the evidence in his case didn't satisfy the two-witness rule. I think that two-witness rule existed, and it didn't exist for this reason. It probably is the main cause for the adage, quote, "Any Sanhedrin that executed someone more than once in 70 years was a hanging cord." It really was to make the death penalty difficult. So it was my job to entangle, if possible, Connecticut's law that cited the pasuk on the two-witness rule, the sentence in the Torah, from the state's two-witness rule that was applied for the last couple of hundred years. I did this by tracking how the two-witness rule was applied historically in Connecticut, going back to the earliest recorded homicide cases, and understanding how the law in Connecticut differed from halacha. It became clear that there was a caveat in the Connecticut statute that didn't exist in halacha. The statute said no person may be convicted of a capital crime without the testimony of two witnesses or the equivalent thereto. That caveat, the equivalent thereto. I explained to the Connecticut Supreme Court how that caveat diverged from the original biblical source and how that meant practically improving a case. For our purposes, I also learned when I was learning with Shlomo that even though the Sanhedrin was guided by very, very strict rules, a king could actually enact laws to deal with certain problems that had become very common. If murder became a common problem, you pass laws that deal with murder a little bit more harshly in order to try to stem that particular problem. And I argue that's exactly what the Connecticut legislature did when they added the caveat to the two-witness rule, or the equivalent thereto. In Ross, the jury had the defendant's detailed confessions about the crime, just, as I said, some gruesome details. Also, we had evidence corroborating almost everything he said. Corroborating evidence is evidence that confirms that if he says he did this, there's a piece of physical evidence that says, yeah, he did it. If he says he did this to the young lady, there's a piece of evidence that proves he did it. Connecticut, interestingly enough, like the Torah, will not accept a confession to a crime without evidence of that crime to actually prove it. It will accept confessions. A person can be convicted on a confession, but there has to be, it's called the corpus delicti rule. There has to be actually physical evidence. Here there was.
Sufficient evidence, just supporting evidence.
Corroborating evidence.
Corroborating.
Yeah, corroborating evidence. And the evidence, there's always been a debate, does that evidence have to be proved itself beyond a reasonable doubt? But under our law, the only thing that has to be proved beyond a reasonable doubt are the elements, not the specific facts underlying the elements. See, I like this, I'm an appellate lawyer. I live in this world. But I argued to the Connecticut Supreme Court that the equivalent thereto language was exactly covered by the evidence that we provided. The Connecticut Supreme Court agreed and rejected his claim on the two-witness rule. But that really wasn't the meat issue, and that's not the issue you really came here to hear about, but it kind of lays the groundwork for how I got to where I got. The morality of the death penalty applied in many, many ways to the equation, specifically to the claim that the death penalty was a per se violation of the state constitution. This means the very existence of the penalty, forget the law that was written to cause it, was, I don't know, how would you say per se? Absolutely barred by the Constitution. No matter how you drafted the law, the Constitution forbade the death penalty. That's where the issue became toughest. The key terminology you need here is as follows, and some of it you've heard a little bit before. A claim that the death penalty is unconstitutional relies on the notion that citizens are shielded from cruel and unusual punishments. If a category of punishment, here execution, fits certain rules, certain criteria, it becomes unacceptable to society. When you put the criteria, the measures, that's the different rules together, you're trying to evaluate. Here's what the court's trying to evaluate. And remember these terms, the evolving standard of decency. What is today's standard of decency compared to when the Constitution was passed? Notice what that does to the law. It does, first of all, give the law life. The law evolves as supposedly the people evolve. We're not necessarily bound by what people believed in 1870 and 1818 and 1650. The law is allowed to evolve because our understanding of what is moral or not has evolved. I don't know how true that is, but that's the equation that both the U.S. Supreme Court ruled and the Connecticut Supreme Court dealt with. Technically, for any punishment, whether it's a jail term, we've recently dealt with the life sentences for juvenile offenders, or the death penalty, for any crime to pass this standard, it has to accomplish, it has to succeed in doing one of three things. It has to rehabilitate the prisoner, deter future crimes, here murders, that is, convince other people that, hey, I'm not going to murder somebody because I could be executed, or retribution on behalf of the defendant, the victim, and society. If it does any one of those three things, it should satisfy the Constitution. Well, clearly the death penalty is not to rehabilitate. You put the guy in jail and you kill him, you're not trying to make him a productive member of society anymore. But I'll tell you, remember I talked about mitigating factors, reasons to spare the defendant? The defense bar went to great lengths to prove that the defendants would be really good prisoners in jail for the rest of their life. They would be rehabilitated, and they would be good prisoners in that they would behave themselves and not cause any trouble. That was offered to juries and judges alike as a mitigating factor. So it's not rehabilitation in the classical sense of putting them back in society, but it was offered in that regard. But dealing with the real concept of rehabilitation, Connecticut's law said if you execute somebody, if somebody gets the death sentence, basically the jury or the judges have determined that there's nothing good to say about this person. They're not going to become a better person. There are some other details about these defendants, what happens to them in jail, that I really will not talk about here, but just a brief little aside. These guys relive their crimes and continue to get pleasure from them. Just think about that when you think about somebody spending their time in jail. Think of the terrorist who continues to get pleasure out of the fact that he or she did what they did. They don't think twice about it. So deterrence really doesn't, but rehabilitation really doesn't fit into the debate. So the focus was on the two latter issues, deterrence and retribution. Deterrence is an interesting debate. Anybody here know what deterrence is? Any students? What? Prevention. You punish somebody to set an example so nobody else will commit the same crime. Now there are studies out there that show that the death penalty does not deter homicides. Conversely, there are studies out there that show it does. Anecdotally, we happen to know that there are criminals who have adjusted their conduct because the death penalty was in play. I knew a reporter who used to go to the jails. His beat was the prisons and the courthouses, and he talked to numerous defendants. One guy, he committed a robbery with a gun, but it wasn't loaded. And when the reporter said, "Why wasn't it loaded?" He said, "Because I could have shot somebody. If I shot somebody, I'd be on death row now." That was at a time when Connecticut not only had the death penalty, but actually executed people. And there's very strong data that having the death penalty on the books is not a deterrence unless you execute the guilty. If you just have it on the books, it has no deterrent effect. In the end of the debate, the people trying to prove that the death penalty was unconstitutional had to prove that it didn't satisfy any of these requirements, and they didn't prove that deterrence was out of the picture. We then come to retribution. That is punishment. Here the Torah understands so much about human nature, so much about how society thinks, especially what we deal with in modern society. Studying with Shlomo, I learned that the Torah considered murder such a horrendous assault on the very fabric of society, of what keeps us civilized as people, that in order to maintain society, indeed, in order to restore it after it's been damaged by a murder, capital punishment was an obligation, not just a power of government. United States Supreme Court Justice Potter Stewart recognized the same thing centuries later when, in Furman versus Georgia, he wrote, quote, "When people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they deserve, then there are sowed the seeds of anarchy, of self-help, vigilante justice, and the lynch mob." Justice Stewart's statement in 1972 aligned with the philosophy of the death penalty that was taught to me through Rabbi Yafi. It made a connection for me. I decided personally that I agreed with Justice Stewart's statement that without enforcing our laws, we can become a wild, unruly society. That helped me along my path to doing my job. There's yet another argument that always is front and center in the death penalty debate. Is it moral for society to intentionally murder a fellow human being? It makes us no better than the murderer, right? I mean, we're doing the same thing. That argument is really important in the death penalty debate. For me, I found the answer in the pasuk, the sentence itself, which our forerunners in Connecticut used to adopt the death penalty. You know, many times in the Torah, when there's a penalty for a crime, it says, mot yumat. The person should be put to death. With a murder, it's different. It says, tirtzach et harotzeach. You shall murder the murderer. Society is required to act intentionally with forethought and planning, just like the murderer. This is a very simple concept, but it really made a strong impact on me. I found it very profound. But we're not really just like the murderer. What's the difference between the murderer and the government in this regard? What's the difference?
Reacting to a crime, one's producing the crime.
Right. First, the citizen makes a choice to commit a crime that he knows brings on capital punishment. Second, do we just kill him right away? Due process of law. It's only after due process of law. So while we intentionally murder, while we plan it, while we use the structures of government to execute somebody, we do so in quite a different way. That was just another thing that informed my belief that that particular argument had no merit whatsoever. Yet another argument offered by those opposed to the death penalty was the following, quote, one person is already dead. Why kill yet another? Have you heard that argument at all? That's very popular in the United States. I learned two answers to this argument, one of religious significance and one expressly set forth in the Torah and its commentary. The first, I'm going to touch on the religious one because I said earlier this was probably important to the people who framed Connecticut laws. Under religious law, the execution actually benefits the person being executed. For until he is executed, he could never be forgiven for his sins in heaven. That's the religious reason, and that probably held great weight to our forerunners in Connecticut. The second lesson was much more provocative for the modern day discussion. It comes from a later pasuk in the Torah that expressly states regarding executions, lo sochot einecha, don't turn away your eyes. Rashi's very comment on that statement is, you shall not say one victim has already been killed, why should we kill another? Rashi, how many hundreds of years ago? Defining the Torah, the source of these laws, had already said to us, society becomes weak and immoral when it can't enforce its own laws. You know, modern thinkers always think that they have the high ground, the moral high ground in this debate, but clearly they're wrong. It depends on your view of morality. For me, I concluded that the death penalty was not simply acceptable, but society's moral obligations to its citizens, to its sense of order. I can now defend capital punishment aggressively, having no conflict with my personal or religious values. But I don't want you to think that what I learned I kept to myself. Far from it. The state's brief, the brief that I wrote, cited the Torah, Rashi, Rambam, and a linear translation of the Chumash. I wove together in my counter-arguments all the concepts that I've been describing to you today, some in a little bit more detail. Though the justices never cited any of that in their opinions, I have it from very good, reliable sources that for more than one justice on the court, that part of the analysis took the edge off their decision to, in 1994, find the death penalty constitutional. They agreed that the defense and those opposed to capital punishment did not hold the moral high ground in the debate. And you have to understand how important that was, because if someone is just so swayed by the emotion of the death penalty, reasoned arguments often can't get through to the judge just by being able to level the field, to make it seem, wait a minute, there's a strong moral argument here. There might be a moral argument here, but there's a strong one here. I was able to talk to the court about how our statute worked, the technical parts of the statute. In fact, I actually got to persuade them that the death penalty in Connecticut, the way it was structured, wasn't just constitutional, but superior to statutes in other states. And this latter point relates to two other notable aspects of my professional versus personal reconciliation. Recall earlier that I spoke of the difference between the rotzeach, the murderer, and tirtzach, the act of murdering. The first kills intentionally, viciously, and often without notice. Whereas the government executes only after the defendant is caught, makes a decision, is caught, and has due process of law. Connecticut's process in this regard was both extraordinary and really exemplary compared to other states. First, Connecticut's death penalty was strict, very strict. It had so many ways out that it ensured only the most deserving people ended up on death row. Whereas the Connecticut Supreme Court required only one level of aggravating factors, Connecticut made state prosecutors prove 3. That had an effect on us as prosecutors. Prosecutors just didn't bother seeking the death penalty unless we were 100% certain that the person was guilty. And by the way, that proved too. The 11 men on death row, even up until this date, not one of them claimed that they didn't commit the crime. That just wasn't part of their defense. Second, Connecticut has a wonderful public defender system. Indeed, the public defenders created what we called the death squad. These were lawyers specifically trained in doing capital cases. Every defendant, from his trial to his appeal to any further proceedings, got the best lawyers, the best death penalty lawyers they could have. It was the quality of that work that made clear to me that if we executed anyone in Connecticut, that person would deserve it, have had full due process of law, have the best lawyers to ensure that due process was provided, plus more process, which, believe me, they did. They made the litigation very, very, very complicated. I'll end on 2 historical notes for clarification. First, in 2012, the Connecticut legislature prospectively repealed Connecticut's death penalty. Here's what their intent was. Anybody on death row could be put to death, but from the date the statute went in effect further, no more death penalties can be imposed, no matter what the crime. So basically, you're on death row, you've been sentenced to death, you stay on death row. In the future, nobody else could be sentenced to death. The Connecticut Supreme Court in 2015, in a case called State versus Santiago, a case I argued, held that because of this new law, executing those on death row would violate the state's evolving standard of decency. The death penalty was declared unconstitutional under the state, not the federal, under the state constitution. And presently, Connecticut, like Massachusetts, does not have a death penalty because of what the court ruled. The second historical clarification is this. Well before that ruling in Santiago, on May 13, 2005, Michael Ross became the first and only defendant executed before the law was invalidated. He was what we call a volunteer, in that once the required appeals, there were certain appeals that were required, were completed, Ross refused to allow his lawyers to pursue other avenues of relief. I was the lead appellate attorney throughout that process, which, despite the fact that Ross was a volunteer, it took us 6 months to litigate. 6 months to get him litigated, even though he wanted to be executed. It was an arduous and exhausting journey. The case went before the Connecticut Supreme Court 6 times. Sometimes we only had overnight to write a brief and argued it the next morning. Did the same thing in the Second Circuit Court of Appeals. We'd send them a brief at 10 o'clock at night, and at 2 o'clock in the afternoon we would be arguing. 4 times it went up to the United States Supreme Court on motions, which we won to allow the execution to go forward. Michael Ross was executed at 2 a.m. on May 13, 2005. In the end, when he was finally executed, all of us on the prosecutor's side were confident that we fulfilled the Torah's mandate. Tzedek, tzedek, tirdof.
Okay, so we'll take 2 questions if you have.
Yep.
Sir, thank you so much, by the way. Great work. So you speak of, in terms of constitutional interpretation, an evolving standard of decency.
Correct.
And you also speak of a kind of a way that you combine an understanding of the Torah and understanding of legal procedures, specifically in Connecticut. So how would you address the problem of a lack of evolving of standard of decency in halacha, meaning today we exist in a society where most rabbis, even in Israel, agree that halacha, in terms of halacha, is evolving slowly, maybe for good reasons, but too slow for the morality of the world.
The way I look at it is this. I don't think that morality evolves in one direction. We operate under, I think, an arrogance to believe that we always have today better ideas than they had 20 years ago, 50 years ago, 200 years ago. And I don't think that's necessarily so. We have standards for sure that supposedly the world believes in. Has it made the world a better place? Some of them, absolutely. Some of them, not so much. Sometimes evolution is damaging. Sometimes it's just an experiment. It's really important that we understand, especially for prosecutors, we often have to defend these root concepts of our Constitution. Because, my goodness, they've held the country together, they've kept it free for 270 years. It's worked. Not every change, not every evolution is good. So I would look at it that way, that you don't always have a better idea today than you had yesterday. And I can see, and there seems to be some fudge room in the Santiago decision that invalidated the death penalty, that if certain things happen in Connecticut society, the legislature could repass the death penalty. And I'll tell you, by the way, 75% of the citizens of Connecticut want the death penalty. 65% of the citizens did not want the legislature to pass that statute. And when you told a Connecticut citizen in a poll what a particular defendant did, remember I told you about the three aggravating factors? 82% of the people wanted him executed. I mean, the polls were overwhelming, so I don't see how our court, and by the way, I said this to our speaker, how you evolve a standard of decency that differs so radically than the population who you serve. They believe in the death penalty. They believe that for certain crimes in certain instances, it's the right thing. In terms of halacha, I don't think all evolution of halacha is good. I think halacha has to evolve certain ways just to deal with the times. The rabbis who deal with the death penalty now, I don't know what their reasoning is. I haven't studied it, but I can only tell you that for me, for my personal journey, all the arguments were there on both sides. But for me, the arguments that made sense was this was a valid halachic concept that could be used in a civil society with a fair conscience. I could sleep at night, better than sleep at night. I could look myself in the mirror every day and say, you're doing something important. So halakha gave me the edge that way. If halakha would have told me that you can't have the death penalty, I still would have had a job to do. We have many Catholics in my office, really devout Catholics, who will not do a capital case because the Vatican says the death penalty is immoral. We have other Catholics in our office who say, I don't believe in the death penalty. When I faced that dilemma, I told you which side I came out.
Specifically, what would you think on, for example, gay marriage, which is in terms like morally
outside my pay, above my pay grade.
You're retired now.
And I'm retired anyway. I'm getting paid even less.
Position and everything.
Yeah. Any other questions? Please. I'm an appellate lawyer. Any questions?
Did I understand you said Ross was the first and only person that
The first and only person executed under the modern death penalty statutes. The last person executed was a mass murderer in I should know this off the top of my head. It's like 40 years earlier, almost 50 years earlier. He was a mass murderer. Interesting. You talk about deterrence. You talk about rehabilitation, and there's also another aspect of it, of the death penalty, and that is you prevent this person from ever doing anything wrong again. Incapacitation. Joseph Taborski, they called him Joseph Mad Dog Taborski, murdered like 5 people. He was on Connecticut's death row. He was about to be executed when a lawsuit was filed on his behalf, claiming that the key witness against him, his brother, was crazy, and his testimony couldn't be believed. It got litigated, and he won. He got taken off death row. We couldn't retry him because the key witness was crazy. Went back out in the population and killed 6 or 8 more people.
So you just made, if I understood, you made 2 arguments against the death penalty doesn't work for as a deterrent. Because in Connecticut, there was only ever one. You said earlier that it's not good enough to have the law. You need also to carry out the law.
You need to execute people.
So in Connecticut, there's no evidence to say that having the death penalty is actually a deterrent because it wasn't used. And in one case where it was almost used, this guy just went back out. And
You sound like Justice Palmer, who wrote the majority decision in Santiago. We had this very debate across the bench. The problem with that argument, and it's really a technical problem in constitutional law, the defendant comes before the court and says the death penalty is unconstitutional. The burden of showing that is beyond a reasonable doubt, because we assume that the legislature has taken all this into consideration, legislative fact-finding, and they've evaluated that argument, and they've said, look, it's good enough for us. So it's not that there's no evidence that it was a deterrent. There's no evidence that it wasn't a deterrent. That's the proper scope of analysis. If one life is saved for having it, it's got value. But in all frankness, studies have been done that if you don't execute people, that immediacy isn't there. But supposedly, like for every execution, there's different data, and I really don't remember it specifically. There's different data on it, but for every execution, a life is saved. A guilty person, an innocent person, I don't think that's a bad trade.
You talk a little bit about the complications that come with the method of execution.
Absolutely. I litigated that case as well. Any specific question?
Well, I mean, it's both. It has different elements, for moral, political, and legal. Right?
The method of execution.
Yeah.
In Connecticut, we used a combination of 3 drugs. Let's see, a barbiturate, pancuronium bromide, and then potassium chloride. The first one was to put the person into such a deep sleep that they would be insensate. They wouldn't feel any pain. The second one, pancuronium, was to really disengage the muscles, because even when someone's unconscious, muscles can twitch involuntarily, make it look like somebody's struggling when really they're just asleep. And the third one was used to stop the heart. It would stop the heart in 3 or 4 minutes. We litigated that issue before the United States Supreme Court litigated the issue. Why those 3 drugs? Why did we choose them? Well, we chose them because one of our experts testified that those are the drugs that are used in open heart surgery. You give them the barbiturate, a certain amount based on the weight of the person, to put them in sleep so they don't feel anything. You don't put them into a deep sleep because you're trying to keep them alive as opposed to executing someone. The second, pancuronium bromide, was used so that the person would lay there still for the surgery to be completed. The third one, to stop the heart, was used if they had to use the heart-lung machine, because if they actually had to work on the heart, they had to stop the heart from beating. And people would be operated on, their chest would be cracked open. Open heart surgery is pretty brutal. Not the way it's done now, but you actually crack the chest open. Not one of the patients, he was an anesthesiologist and a pharmacologist. Not one of the patients ever operated on said that they remembered or felt any pain during the operation. Now that was based on a drug, barbiturate that was given to them to keep them alive. The execution barbiturate was like 100 times that much. Most people would have died just from that. They would have fallen asleep and just never woken up. The other process was designed to make the process a little bit more expeditious. And I believe Justice Scalia, in one of the early cases, talked about what the victim went through during the homicide. How the defendant shot her, chased her around, shot her with a shotgun again, chased her around, shot her with a shotgun again. And he said something, I'm paraphrasing, something along the lines of, falling into a deep sleep and passing away is certainly preferable to what he did to his victim. So there are humane ways of doing it. The arguments against the drugs are absolutely I mean, they're really kind of outrageous, some of the arguments against the drugs. The problem we're having now is that companies won't sell the drugs. A lot of these drugs are only produced in some foreign in countries outside the United States. They won't sell the drugs to corrections departments for executions. Corrections departments have to find other drugs. Every time you introduce another drug, another lawsuit is filed, claiming that drug creates cruel and unusual punishment. Remember that term? Cruel and unusual punishment. The person suffers when they are executed. They die a painful death. One of the justices of the Supreme Court, when we were arguing this issue, said to me, Mr. Weller, how the heck do you know that they don't suffer any pain? I said, because our expert testified that of the thousands of open heart surgeries that they did, not one of the people who woke up said it hurt. It's a pretty sure thing. The Connecticut Supreme Court found the method we use constitutional. The U.S. Supreme Court, in the case Bates versus Reese, left the area wide open. I think you can find many. Look, one of the most humane ways to execute somebody is hanging them. But you have to know how to hang them. If you hang them improperly, they just, flutter around for a while until they're strangled. There's an expertise to tying the knot. There's an expertise to placing and there's an expertise to doing that type of thing. Just thinking about the expertise. One of the complaints about the medical methods of using the drugs is that doctors won't do it because they're not allowed to do no harm. That's their pledge. So since doctors won't do it, you have to find technicians. And they say the technicians aren't skilled enough. And they'll botch the execution. You can go online and read about botched executions. They've been studied, and what they consider botched is the execution going bad, but not necessarily, not the person you made suffering. Executions have gone bad.
So two arguments that are also visible in the debate against the penalty. One was actually very much pronounced in the Israeli Knesset debates in the 1950s. Is about the possibility, not only the statistical, but also kind of the philosophical possibility of mistake.
Yeah.
It also has a religious dimension, right? That humans cannot know everything 100%.
Absolutely.
It's a matter of definition of what it means to be human. And if that's the case, and if there is even, again, either a statistical or philosophical possibility of mistake, then we should not sort of close the door in the sense of putting something. That's I was wondering about that.
Well,
okay,
that's where that was also debated in Santiago very fiercely, actually, in the following case between myself and Justice Palmer. If you remember, I told you that Connecticut had the 3 levels of aggravating factors. First, in Connecticut, it has to be an intentional murder. The U.S. Supreme Court doesn't require that. Secondly, there had to be an aggravating factor: torture, murder for hire, something like that. Third, so you got to have an intentional murder. Intentional murder, and then there had to be an aggravating factor in the crime: a police officer, a child, you murdered during a rape, you murdered during a kidnapping. That was just defining the crime. Then we had to prove beyond a reasonable doubt an aggravating factor: torture, murder for hire. You committed a murder previously in your life. It was so hard to do that we never even sought the death penalty against people who we had any doubt were guilty. And in the debate I had in the Supreme Court, and you can actually watch the debate if you want, the argument if you want, Justice Palmer said to me, we could still convict an innocent person because anybody who committed their crime before the new statute could still be sentenced to death, theoretically. And I said to him, on what history do you base that? There are 11 men on death row, and we know they're all guilty. You don't operate, when the statute has to be held unconstitutional beyond a reasonable doubt, when all the evidence is you only put guilty people on death row, how does that argument sway the court? It did in this case. It did in Santiago and Gila. But I think if the statute itself is protective enough, and I really have a lot of confidence also in the public defender system, if the process is very, very stringent, arduous, it shouldn't be easy. Good prosecutors who've sworn an oath are only going to seek the death penalty against really guilty people. And I will also tell you, by the way, not only don't the defendants contend that they didn't commit the crime, at the trial, they didn't even contest their guilt. The whole trial, is geared to the sentencing hearing. Everything they do is geared to the sentencing hearing. Because usually the same jury or the same panel hears the guilt phase and the sentencing phase. They're two separate phases. It's all psychologically geared to that. They know we're going to prove guilt because they're guilty, for goodness sake.
The other argument, still different, maybe goes closer to your own experience, is we hear this also in debates about interrogation techniques, the effect on the interrogator or on the person involved in administering the death penalty, and perhaps also arguing the death penalty. Society is imposing the cost on a system that has to administer this sentence. That includes the lawyers also have to argue for it. Just wondering, how does it feel to be part of a system that eventually puts people to death? Right?
I was hoping that I described that here, but frankly, you never celebrate. You don't define victory as a prosecutor by necessarily winning the case. You justify being a prosecutor by ensuring that you've done justice in your work. We did justice here. We put a guilty man to death according to the law. We followed every procedure, every step. We gave him every opportunity to get out of the system as the law provides. I'm very proud of our work. But you never celebrate the fact that you have to do that. But that goes back to lo sachot einecha. You can't be afraid to do what's right. If you don't do what's right, when you don't do what the law says, then you are pandering to the worst of society. This just happens to be at a very high level, a very high degree. It is the ultimate punishment. I was exhausted after all of these cases, but once I had resolved this, I was very comfortable in believing that the death penalty is a valid social tool. I will tell you, however, I have no problem if the legislature decided to get rid of it, because that's also part of our social contract. The citizens decide through their representatives, but that's not what happened in this case. The citizens' representatives wanted to keep it, the citizens wanted it, the court didn't. So I'm a really big believer in the system. The adversary process worked on the Ross case. The political process didn't work in the death penalty situation. So I can live without the death penalty. I can enforce it if it's there. You had a question?
Yeah, I'm not sure. I was asked for a while in the phone call. I'm not sure if it was asked, but isn't the level of proof required to convict for capital punishment the same as for life?
Yes. Well, the burden of the level of proof is the things that you have to prove are greater. Or, for instance, if you fail to prove something required for the death penalty, let's say...
But the level, no, but I was talking about, my question related to the burden of proof.
Beyond a reasonable doubt.
Beyond a reasonable doubt.
Right.
Now, under the so-called Innocence Project, that there were several people who were convicted, meaning that they went through the American system and were proven beyond reasonable doubt to be guilty, and once that DNA examinations came out, it was proven that they weren't there, it wasn't them, and they were actually wrongfully convicted, and these people were innocent of the crime that they've been convicted of. Doesn't that make you doubt?
First of all, were they executed?
No.
No, they were vindicated by the system.
But they were...
they were vindicated by the
after
system.
so many years. But before that, they were convicted beyond reasonable doubt.
A prosecutor's greatest nightmare is an innocent person being convicted. It's the greatest nightmare in the world for a prosecutor to do that. I'll give you two answers. The first one is that. But I'll tell you something. If you compare the error rate in the operating room to the error rate in the courtroom, you'll find that the error rate in the courtroom is far less than the error rate in the operating room. Do we not do surgeries because doctors make mistakes? Do we not have surgeries because a patient may die? You don't evaluate. It informs the judgment. It clearly informs the decision. But one of the reasons I made it was easy for me in Connecticut was I never had to worry about that problem. Because the prosecutors I worked with, once I became rather expert in this field, the prosecutors called me sometimes before the guys were arrested. Sometimes they called me to come down to the police station during interrogation. We didn't seek the death penalty unless there was just no doubt that these people were guilty. And none of them claimed they were. That's why I was very confident in Connecticut, and that's one of the things I said to the justices in the argument. I said, you don't have a history of innocent people on death row. There's another thing I want to tell you, is that make sure actual innocence is your definition of it. That they didn't commit the crime. Not the definition of evidence has come up which indicates they may not be guilty. Because the two things get confused. Actual innocence is they didn't do it. A witness changing their mind, testifying differently, isn't the same thing. But what you said informs the debate. It informed my beliefs. But since I didn't have to worry about it in Connecticut, the dial was well over to where I was very, very comfortable. And I was enforcing Connecticut law, not Texas law, not Ohio law. Our statute was so difficult. The defense attorneys were so good. The prosecutors were so good. And justice was done.
So, two questions really quick. First of all, so what would you say? Meaning, you're saying the Torah upholds a certain standard of morality, but in terms of justice, especially having to do with murder, you have a very large morality system built upon an eye for an eye, or like the Il Miklat, which, even if you look at it from today's standards, aren't the most moral of laws. Meaning, if I murder the person even by mistake, his family can kill me until I get to a certain city.
Right.
I have to stay there for almost my entire life,
Unless it's an old Kohen.
somebody happens to die, right? So that's not the most moral of systems, and neither is eye for an eye.
Well, first of all, lex talionis, eye for an eye. I've always thought that that was misused. I was always taught that it was misused. Eye for an eye, tooth for a tooth. What are they talking about there? Yes. It's the basic definition of compensation in a civil action. That is inconsistent with our evaluation of, you guys do tort law, right? But you study tort law, right? Somebody gets their arm cut off, what compensation do they look for?
Not an arm.
The value of the arm. The value of the arm. That's what eye for an eye was. So to say that that's
And
not...
just to add that Maimonides says that why it's written an eye for an eye, not a compensation or damages for an eye, because you ought to be, your eye should be taken off because that's what you did. That was the original law maybe, but because it's not efficient, because it doesn't make maybe a sense, you won't do it. But the Torah wrote an eye for an eye for you to understand that this should have been originally what should have been to you, should have been done to you. It's like the kaparot that we'll do before Yom Kippur when we take the chicken or the money and they say that this chicken will be slaughtered, but this should have been your fate. Yeah, and you should understand this. We won't do it to you, but you should understand that was your fate.
Yeah. So in that regard, that example, but there are other examples. I mean, there are other examples we can look at the Torah and say that we wouldn't do that today. But murder hasn't changed. Murder hasn't changed since the beginning of time. Intentionally taking another human life, sometimes doing it brutally, has not changed since the beginning of the time. The damage it does, forget about the victim's life, is terminated. Brutally, suddenly terminated. The effect it has on families, the devastation it causes families, the ripple effects that causes, none of that's changed. So to say that the moral component of the equation has changed, no, it's just how you assess and weigh the values.
So would you say the judicial process today is perhaps too stringent to an extent that it is immoral?
I think, and again, I'm going to tell you something I said to the Connecticut Supreme Court. One of the things one of the justices said to me, again, Justice Palmer, who was my main adversary in this because he wrote the first opinion and we were trying to get that overturned. Just as an aside, Justice Palmer is a dear friend of mine. He was at my daughter's wedding. I lost my train of thought there. We're talking about the justice system. Yeah, He said to me, but we're not doing it. It's taking so long. We're not executing the people. And I said, this is exactly what I said. Whose fault is that? It's this court's fault. He says, what do you mean? We're supposed to police the litigation? I said, absolutely. You did in the beginning. The first brief was 300 pages. The second appellate brief was 200 pages. The third brief was 100 pages. As the law got developed, this court narrowed it, which would have sped up the process. I said, you haven't policed a case in 20 years. Now we get 600-page briefs, relitigating claims we relitigated years ago. You don't make the defense have any deadlines. You don't enforce any of the rules. It's your fault, Supreme Court. And what you do is viewed by the people below you. That's what I said to the court in argument. So the death penalty is not defective because of the delay. You're not doing your job. So yeah, it can be fixed.
You said that to
You better believe it.
Supreme Court judges?
I said that to a Supreme Court
You weren't
judge.
held in contempt?
Absolutely not.
Okay, so I want to close with a Jewish democratic question. When you touched upon it a bit, but when you study the Sanhedrin Tractate, I think that you clearly see that that in Jewish law the capital punishment is rather theoretical. The parameters are very strict. There's lots of qualifications, and it's as you said, the Sanhedrin that sentenced a person to death was called the katlanit, deadly or hanging court. Yeah, and this is not the case with modern law, like in Connecticut. It's clearly different there, because death penalty is practical. So when you try to draw, try to take similar principles, and so how do you deal with this difference?
I'm not sure.
Because in Jewish law it's impractical. There's so many qualifications, and evident law is so strict. And when you come to capital punishment in your system in the U.S., it is practical.
No, but Benny, he said that in Connecticut.
At the end of the day,
one case.
Yes, but it is practical. They chose not to do it.
They chose not to do it, but that's the tension. But that's the tension. It's a valid tension. The process itself. Look, prosecutors were willing to seek the death penalty. The sentencer could either be a jury of 12 or 3-judge panels. Juries of citizens were willing to impose the death penalty. In fact, after the repeal of the death penalty, that statute that I told you about in 2012, one guy who committed his crime earlier went to trial for a capital case. The jury was told that if he committed the crime today, he couldn't get the death penalty. Guess what they did? They sentenced him to death. Judges imposed death penalties. The people operating the system were not unwilling to do their jobs. And by the way, in 55% of the cases where we sought the death penalty, we didn't get it. Maybe more than that, maybe 60% because of mitigating factors. So, yeah, but, if the justice system turns away its eye and doesn't take care of what it's supposed to do, then the system fails. The mistake of the Connecticut Supreme Court was you blame the death penalty for that, and it wasn't the death penalty's fault.
Okay, thank you very much. Thank you.